so the scenario you just explained was like if Adam didn't respond, but now let's talk about what if Adam, okay,
In
wait a
Eve's
second.
perfect world, the last slide would have been what happened.
Right.
But this is why we have lawsuits and why we have judges and why we go to court.
Right.
So Adam, so again, it confirms that Adam didn't serve and file responding pleadings. So once he's served with the application, if he disagrees with what is being asked for, he has to serve and file an answer. And in a divorce proceeding in Ontario, it's a Form 10 answer. Once he's served with the divorce application, he has 30 days in which to file an answer. And if he doesn't file an answer, he's deemed to have accepted the facts pled by Eve, and he's not contesting her request for divorce, and she will get her divorce on an uncontested basis.
Right.
But what happens if Adam disputes it? So let's move to this scenario. He gets served with the application. He's going to say, well, yeah, I have to respond. So he uses the Form 10 template.
Right.
It's a pleading. The relief that he is requesting is that Eve's application for divorce be dismissed. The grounds for why he is claiming the application should be dismissed is he pleads the law. This is under the Divorce Act, and it is under the family law rules. So it's the same legislation that Eve pled. He says, yep, this is the legislation that applies. Now he's going through and saying, I accept the law that is pled. I'm arguing the material facts. Guess what? We haven't been living separate and apart for a year. She lied. She and I separated on October the 25th when she beat the crap out of me. I had to call the police. They took her out of our home. They arrested her, and she's now facing assault charges, and she was released on bail with terms that the only thing she can go back to our shared home for is to pick up her stuff. She is not entitled to a divorce because the fact is that we only separated a month ago, not a year ago. Material facts do not support the divorce being granted, which require us having lived separate and apart for a year. So he's saying, hell no, don't give her a divorce. Not entitled to it. We've only been separated for a month, not a year. She lied.
Right. Okay.
So now that's where we're at. The evidence that Adam's going to have, the material fact he's claiming is we've only lived separate and apart for a month, not a year. He's not denying they're married. He's not denying that the marriage certificate Eve produced was valid. He's saying the material fact that is wrong, she needs in order to get the divorce is our date of separation. So he does an affidavit where he confirms, yeah, our date of separation was October 25th, 2022, not a year ago, whatever the date was that she claimed. And in his affidavit, he goes through the information about what happened, which is that she assaulted him a month ago, that the police came in and arrested her and took her away, and that she's not even allowed to come back to the house except to get her belongings, because this is just a really recent separation. The evidence that he provides in support of the material fact allegation is he has a copy of the police incident report, which confirms that the assault took place. So the assault is a material fact. The incident report is evidence. And he's also provided a copy of Eve's bail release conditions, which are dated, that show when she was arrested, where she was arrested, which was at the home, and that she can't go back to that home except for the purposes of getting her belongings. But that's evidence that supports the material fact that Adam is pleading, which is we only separated a month ago, not a year ago. And because they've only been separated for a month and not a year, she has not been able to establish the requirements under the Divorce Act to get a divorce because they have not been living separate and apart for a year. Okay?
Right.
Next slide. So now Eve is going to do one of two things. She's either going to say, snap, I've been caught. And she'll agree that the date of separation was only a month ago. She will concede that they haven't been living separate and apart for years, so she hasn't established the grounds for divorce. So she'll just say, all right, can we put this whole thing on hold and let's wait. I screwed up on the date of separation. Oops, sorry, didn't mean that. I'll try again for my divorce in a year. And she'll concede what Adam has said about what their date of separation is. Or she could come back and say, hell no, we actually did separate a year and a half ago. But he wouldn't let me come back to the house to get my stuff. So I've had my own place that I've been living in for the last year and a half. And I finally came back to the house to try getting my stuff. He got mad. He wouldn't let me take my clothes. I pushed him to get to my closet. He called the police.
Right.
The police arrested me. All the other stuff he claims is true. But no, I've had my own apartment for the last year and a half. This assault happened and I got charged with assault because I went back to the house to try getting my stuff.
Right.
And if Adam comes back and says, she's lying, material fact is in dispute.
Right.
This case would have to go to trial. If the parties will not agree on what the date of separation actually is,
Right.
then they both pled what they're claiming are the material facts.
Right.
They can't agree on what those facts are. The basic key pivot fact here is the date of separation.
Right.
If they can't agree on that fact, then the matter will have to go to trial. And it'll be a judge hearing the evidence from both parties that they will produce to support their argument for the material fact about what actually was the date of separation. And the judge will have to make a ruling on what the date of separation was. If he finds that Eve, in fact, did move out a year and a half ago, then the date of separation is what she's claimed in her pleadings, and the divorce can issue. If the judge finds that Adam is the one that's telling the truth and Eve is just mad, she just wants to get shut of him as soon as possible, and she hoped she could slide through and he wouldn't contest the divorce when she lies about the date of separation, if the court finds that's what she did, they'll dismiss her application for divorce because she hasn't established the grounds. They haven't been living separate and apart for a year. So that's how they all come together. So the pleadings in this case, in this situation, would be her application,
Right.
pleading the law
Mhm.
and the material facts.
Mhm.
Adam's pleadings would be his answer, where he confirms the law that's being used to decide this issue is pleaded properly, and he's agreeing that he's using the same law.
Mhm.
And his material facts, though, are different. And then, as I said, either the parties have to agree what the material facts are, or it has to go for hearing and a judge has to decide. So this is what this whole slide just summarizes. The whole key material fact in dispute is that what the date of separation is. So always, when you have pleadings that set out material facts, if the parties don't agree to those facts as being correct and true, then it'll be up to the court to make a decision. And the way the court makes their decision is based on the pleadings. They see the material facts and the law pleaded by both sides, and then they will, in the course of the hearing, have the parties call the evidence to support what they are claiming are the material facts.